Construction Business and Law Manual for Nevada, Chapter 8, Contracts, Overview. By definition, a contract is an agreement enforceable by law made by all parties to abide by these obligations agreed to in the document. If a breach of the agreement occurs, the law provides a remedy if either party fails to live up to the signed contract. It is important that a formal written document be enacted because of the specialized nature of the construction industry. Construction contracts cover different types of projects, involvement of many individuals over an extended period for substantial sums of money. Generally, a construction contract will include the following items: time limits for start, units of work, and completion dates, when and how progress payments will be made, guidelines for employment of subcontractors, procedures for paying for added project costs, time extensions, schedules for payment of bonuses or for withholding payment with cause, and penalties for late work. Pre-contract conditions. The identification of goals and objectives among the parties is the first step in initiating a contractor for a construction project. Typically, this involves a direct relationship with the owner and the contractor. The contractor, in turn, may then manage the project through subcontractors. The contractor assumes all the risks for these subcontractors, and the owner is able to hold this individual responsible. Participants in large construction projects might include the owner and general contractor, but also an architect or engineer, subcontractors, craftsmen, laborers, and material suppliers. Deciding the roles that each of these players will undertake is vital to the overall success of the project. Therefore, all those responsible for the construction process, owners, architects, general contractors, and subcontractors, should be involved in the development and review of the contract documents and make sure they understand the documents before any activity takes place. Before work is begun, a set of documents which will make up the construction contract will be created in detail to set forth the responsibilities of the parties. These responsibilities are defined in the contract and clearly establish the relationship among the participants. Once established in the contract, those relationships and responsibilities become legally binding and form the basis for settling disputes, if the need should arise in the future. But if all the parties to an agreement clearly understand the meaning of the contract's provisions and their obligations or roles in the process, the role of the contract becomes the more important one of preventing disputes. Privity of contract. Privity of contract is a legal term that describes the direct relationships that exist between the parties to the same contract. In a typical construction project, the owner and general contractor are parties to one contract and are therefore in privity of contract. The general contractor and subcontractor sign a different contract and therefore in privity of contract. The subcontractor and owner are not in privity of contract. Only the parties in privity of contract are allowed to sue in the event of a breach of contract. Mutual agreement. The parties involved in the contract must have a genuine intention to take on the obligations of the contract. They must also be in complete agreement about how the terms of the contract will be carried out by everyone involved. Time is of the essence, and liquidated damages. If all parties agree to the condition that time is of the essence, then it is understood that the project must be completed by all the designated contract completion dates. Under these conditions, if the contract completion date is not met, the contractor may incur penalties that have been agreed upon mutually as part of the contract. These penalties are known as liquidated damages. Typically, the liquidated damages rate is a reasonable amount to be paid as compensation for the harm that is caused by late completion or untimely performance. Liquidated damages also provide a means for avoiding future legal action. If a contract incorporates liquidated damages, an owner may not then sue for actual damages. Capacity. Capacity of the parties is a term used to define another element required in contract negotiation. Capacity refers to the ability of the parties to make valid and enforceable contracts. The person who signs a contract on behalf of a company must have the authority to represent the company. A contractor who has doubts about that person's authority can ask for proof that the person who will sign the contract has been authorized to enter into the agreement. Lawful object of the contract. The object of the contract must be lawful. The law will not enforce a contract for an illegal purpose. Basic elements of a contract. Although contract negotiations can cover a wide range of issues and contain many legal clauses, there are principally three basic elements of a contract. These are offer, acceptance, and consideration. Offer. An offer is the demonstration of willingness to enter into a contract. Two essential elements in an offer are the intent to enter into an agreement and the certainty and definiteness of terms. Following are four items that must be clearly stated in a valid offer. Identifications, person making the offer, person to whom the offer is directed, and any third-party participant. Time of performance, period of time in which the activity is to be performed. Price, amount of payment for the work. And subject matter, what the person who makes the offer will provide. The offer is a series of promises in the form of a bid or proposal submitted by a contractor to build a certain project according to the plans, specifications, and conditions set forth by the owner. Both parties must understand completely the difference between an offer and negotiation. An offer must clearly state the specific terms of the agreement, including price, scope of work, scheduled progress, and completion. A statement such as, "We will give you the best product and service for the price," is a form of negotiation, as it is not specific enough to be an offer. If the contractor is in the process of a negotiation and cannot formalize the contract document, perhaps due to not having enough information from suppliers or the owner, this must be clearly stated as such. A communication to the owner should plainly state that the contractor's intent is for negotiation and not meant as a formal offer. Straightforward statements can lessen many of the problems that might arise between the parties as a result of miscommunication. The major element of an offer is that once the other party accepts its conditions, a contract will follow. Bid. A bid is another name for an offer. In responding to an invitation to bid, the contractor will review the bid documents prepared by the party who is requesting the contractor's services. The bid documents generally include the guidelines for the invitation to bid, instructions to the bidders, and any special bid forms. Upon acceptance of the bid documents are incorporated into the contract. Bid documents are discussed in Chapter 7, Estimating and Bidding. Review that, please. By submitting a bid, the contractor offers to do the work under specified conditions for an agreed-upon price. A contractor's offer to the owner should include all of the following vital elements: contractor's name, business address, telephone number, fax number, email address. Many jurisdictions require the contractor's license number and/or monetary limit to be included with the bid. Owner's name, business address, telephone number, fax number, and email address. Date and duration of the offer. Identification of the project and its location. Brief description of the work to be performed. Identification and numbering of drawings, specifications, addenda, or other documents, if any, describing the work. Bid bond, if required. Dates for starting and completing the work. Total contract amount to be paid by the owner. And arrangements for types of payment. Payment on completion, periodic payments, retainage, bonuses, etc. Acceptance. Acceptance is the agreement from the persons to whom the offer has been made and takes the form of a notice of award. The acceptance must accept all the terms of the offer unconditionally. The document containing the owner's acceptance of an offer should include specific reference to the contractor's offer, a clear and unqualified acceptance of the offer, acceptance date, and signatures of the contractor and owner. An owner who does not want to accept the offer unconditionally as presented may reply and propose changes. If the owner's response differs from the initial offer, it becomes a counteroffer. The contractor may be asked to submit another offer to which an unqualified acceptance can be made. Only when both parties agree to all terms is the offer considered accepted. Consideration. Consideration can be defined as a payment given by one party in a contract to the second party for something acquired or promised. In relation to a construction contract, consideration is usually a payment of money for construction work, but it may also be anything of value that both parties agreed upon. Written versus oral contract. The complex nature of construction dictates a form of contract that is usually very long in order to describe precisely the legal, financial, and technical provisions. Construction contracts are different from typical commercial contracts because the project's completion involves considerable time, personnel, cost, and possible hazardous elements. As a rule, contracts need not be in writing. Contracts need not be in writing to be valid, but as a practical matter, they may need to be in writing to be enforceable. Oral contracts are generally legal and valid, but they can result in future problems. The written contract forms the basis of the various relationships among the participants on a construction project and defines their roles. A contract essentially provides a means for allocating risk and specifying rights and obligations among the parties without a written document signed by the parties. The agreed upon terms and conditions are built on the unsteady foundation of memory. If a dispute arises, it is almost impossible to prove whose memory is the most accurate. The written contract, with all the details clearly documented, provides an accurate record. Under certain conditions, however, even that record may be subject to interpretation. Contract interpretation. If a dispute or conflict arises concerning the various elements in a contract, the following generally accepted standards apply. The specific provision is followed over the general provision. The handwritten provision prevails over the typed provision. The typed provision prevails over the printed provision. If there is a difference where numbers are expressed in words and figures, the words govern. When there are confusing or ambiguous terms or descriptions, they are interpreted against the party who drafted the document. In a conflict, if a conflict exists between the drawings and specifications, usually the specifications take precedence, although the general conditions may provide that the architect, engineer, or owner would decide which one to use. Should a construction requirement appear in the specifications and not on the drawings or vice versa, the contractor must provide the requirement as if it was included in both places. And trade terms, industry usage, and customs in a community where the contract is signed are understood to be part of the contract. If any portion of the contract is in conflict with any legal requirements such as code, ordinance, regulation, etc., the contractor should bring this to the attention of the project owner or owner's representative. Contract documents. Generally, contractors prefer contract documents in which the makeup, form, and content are familiar. So standard forms of a contract documents are now used widely throughout the construction industry. Using standardized contract documents has had a positive effect on lessening areas of disagreement among owners, architects, engineers, and contractors. The American Institute of Architects, AIA, the Associated General Contractors, AGC, and the National Society of Professional Engineers, NSPE, are three organizations that provide standard industry contract forms for a fee. All of these organizations can be found on the internet at the following websites. Website address is for AIA, http://www.aia.org. The website address for AGC is http://www.agc.org. The website for the NSPE is http://www.nspe.org. The following series of AIA documents are commonly used in the construction industry. A series, owner contractor; G series, construction administration; CM series, construction manager; and DB series, design builder. Among the AIA documents most often used by contractors are A101, standard form of agreement between the owner and contractor; A401, the standard form of agreement between the contractor and the subcontractor; G701, change order form; and G702, G703, application and certificate for payment and continuation sheet. Additional information about these and other forms can be accessed from the web www.aia.org/documents or by calling 800-365-2724. Standard form of agreement. The standard form of agreement, A101, is one common agreement that both the owner and contractor are required to sign. This document may incorporate all the documents used in the estimating and bidding process, or may include them by reference. Based on the nature of the project and the contract, these reference documents might include the following: bidding documents, general conditions, supplemental conditions, drawing and specifications, surety bond forms, and addenda. Change order forms. The change order form G701 is the document used to record changes to the agreement. Typically, changes such as adjustments in the contract sum and or contract time are made in this form. The change order form can be used with a number of AIA contract agreements between the owner and contractor, and between the contractor and subcontractor. The change order form is used to incorporate other documents into the agreement that support the change, such as request for information, RFI, field directives, letters of explanation from the contractor, and the architect/engineer estimates and pricing information. Often, the general conditions and or the supplemental conditions will establish the requirements for change order documentation, allowable cost items, and allowable overhead profit. Application and certificate for payment and continuation sheet. The application and certificate for payment G702 and continuation sheet G703 are widely used by contractors to apply for payment. Form G702, the cover sheet, is used to record important information such as primary parties, owner, contractor, architect, project name, application number, distribution requirements, original contract sum, changes by approved change order, total completed work, materials stored to date, retainage amounts, previous payments, current payment due, and balance to finish. Form G702 provides for a notary, if required, and has a place for the parties to sign. If other types of forms are used to apply for payment, they will typically follow the G702 format. Continuation sheet or schedule of values. The continuation sheet G703 is a companion document to the application for payment. This form is also known as the schedule of values and is used to provide a breakdown of the work and to document how payment is to be made for progress in the work. The form is made up with rows of information that represent individual line items. For example, site work may be in a single item, or it may be broken down further. The schedule of values is used throughout the project to record current amounts and the amounts completed and stored. This information is updated until the project is completed. Types of construction. A construction agreement may encompass one of several standard methods of construction. These include design, build, turnkey, traditional, fast track, or construction management. Design build. As the name applies, in design build development, a general contractor contracts to both design and build the project. Even if the contractor does not have in-house design capability, an outside architect or engineer can be retained to provide this component of the overall project. Turnkey. The turnkey project is the ultimate form of the design build mode. In a turnkey project, the contractor assumes all the responsibilities for the project, including financing and supplying the site on which the project will be built, in addition to its design and construction. The owner contracts for a total package and is given the key to the property when the project has been completed. Turnkey. Traditional. In traditional construction contracts, the owner hires an architect or engineer to provide the plans and specifications. The owner will then hire a contractor to utilize these plans to build the project. The owner could also hire an architect, engineer, or other project representative to oversee the work of the contractor. In general, these people would act as the owner's designated representatives for the project. The contractor provides construction expertise and will complete the project with company employees doing the work or by employing subcontractors for some or all of the tasks. Fast track. With fast track construction, several prime contractors may be engaged to complete individual segments of a project as the design is completed on various segments of the project. The work for that portion is bid and work is begun before the design for the next segment is completed. This type of construction enables the project to be completed more quickly, fast track than traditional procedures, but requires persistent management oversight to ensure that all the activities are coordinated without going over budget. Construction management. This type of delivery method is typically used by public entities for large-scale complex projects by owners who have ongoing renovations and additions to their physical plant. The primary difference between the traditional method and the construction management is that the construction manager is considered to be the agent of the owner. The construction manager operates solely in an administrative capacity and does not self-perform construction work. The construction manager's fee is generally a percentage of the cost of the project. Typically, the construction manager guarantees the owner a maximum price before the project is bid out. The construction manager then pre-qualifies individual bidders and solicits competitive bids for all portions of the work on behalf of the owner. The construction manager will return to the owner the difference between the guaranteed maximum price and the actual cost of the work. Awarding contracts. Construction contracts may be grouped in two major categories. The first includes contracts for which competitive bidding is required. Almost all public construction contracts and many private contracts fall into this category. Competitive bid contracts are typically formulated on a fixed price basis and consist of two types, either the unit price contract or the lump sum contract. The second major category is comprised of construction contracts that result from direct owner contract negotiation. Negotiated contracts can be formulated on any mutual agreeable arrangement. Negotiated contracts can be a cost-plus fee basis in which the owner reimburses the contracting firm for all construction costs, plus compensates it for services rendered. Other negotiated owner-contractor contract options can include the lump sum or unit price method. Direct purchase. Owner sales tax exemption. Many public sector owners and private nonprofit organizations are exempt from sales tax imposed by state and local jurisdictions. The savings for the owner can be significant, especially for a large project. Benefits for the contractor. When owners choose to exercise their tax-exempt status, the contract will often require that the contractor be responsible for managing direct purchases to capture these savings. This can also become a major benefit of the contractor because cash flow for the purchase of those items is not covered by the retainage that the owner usually holds on to the contractor's payment. Most vendors will not allow a contractor to hold retainage, but the owner will almost always withhold it from the contractor under the agreement. Contract requirements. The tax-exempt feature of the contract should be clearly understood before the contract is bid. Some specifications will require that sales tax be included in the original bid. Then, after the contract is awarded, the direct purchase items and the applicable sales tax will be deducted from the agreement by means of a change order. However, in some cases, the specifications will note certain items for which tax is not to be included in the bid at all. Before bidding on a contract that would involve a large volume of direct purchase materials, the contractor needs to consider the additional management and coordination tasks required, which should be accounted for in the bid price. Direct purchase process. Typically, the owner will issue purchase orders directly to the contractor's vendors, but the owner will almost always require the contractor to be totally responsible for handling the direct purchases, as well as fulfilling the technical specifications, schedule, and all other conditions of the contract, just as if the contractor were actually providing the purchased items. Technically, however, the owner is purchasing the materials and must do so in order to capture the tax savings. It is advisable to limit these purchases to items that can be delivered directly to the job site, since the owner holds a tax-exempt status. The records will clearly show that these deliveries were made to the owner's property. If for some reason the contractor needs to take direct delivery of materials, such as an order for raw materials that must be fabricated in a shop or yard, and the owner's sales tax exemption is not used, the contractor must have a certificate for resale issued by the state. In this case, the contractor would use a certificate for resale when the purchase is made. However, the contractor must still maintain the owner's tax exemption certificate on file for the period that covers the purchase date with these documents. With these documents, the contractor will not be required to pay the state tax nor to collect the tax from the exempt owner. Without this certificate, the contractor may have to pay the sales tax. This could become a major problem if the contractor's purchase was found to not meet all the criteria for an exempt purchase, and the contractor had already credited back all the applicable taxes to the owner. This is one example why it is so important that all requirements for using certificate for resale must be met, including regular monthly or quarterly filings with the state. Most states aggressively police state sales tax payments and conduct regular audits. There are other qualifications that a contractor must meet to legally avoid sales tax payments. If it is advisable to check with an attorney regarding different contracts so that the contractor does not pay sales tax when the contract does not require it. A contractor who plans to enter into contracts on projects with tax-exempt owners who require direct purchasing should find out how to obtain the state sales tax certificate for resale. Refer to Chapter 12, Tax Laws, to obtain contact information for obtaining a state certificate of resale. Contract payment basis. Several different construction contracts have been developed to suit the nature of how the project is negotiated, enabling a contractor to select from a variety of construction payment types. A fundamental difference among contracts is the focus of financial risk. Some contracts place more financial risk on the owner, others put greater risk on the contractor. Cost plus contract. Cost plus contracts are normally negotiated between the owner and the contractor. Most cost plus contracts are open-ended in the sense that the total construction cost to the owner will not be known until completion of the project. In a cost plus contract, the owner agrees to pay for all construction costs, labor, materials, equipment, etc., in addition to a specified amount to the contractor. This specified amount provides the contractor payment for overhead and profit. The amount may be determined in a number of ways: a set fee, a fixed percentage, or a sliding percentage of the total costs. Some cost-plus contracts set a maximum cost ceiling. In this circumstance, the contractor is liable for any costs that go beyond the stipulated maximum amount. Additional provisions can specify a fee limit, a fee minimum, bonuses for early completion or superior work, or penalties for late or below standard work. The cost-plus contract usually includes an estimate of the targeted total project cost. When a cost-plus fee method is used, the fee is set in the contract. When the more open-ended cost-plus percentage method is used, the contract must clearly establish which items will be included in the total cost and list of items to be paid by the owner. The cost-plus fee contract is often used when costs can be reasonably well defined. The cost-plus percentage contract is useful in situations in which an accurate construction estimate is not possible. Either method is often preferred by contractors more than the other methods, because both methods help protect the contractor from liability for unexpected costs. Fixed price or lump sum contract. In a fixed price or lump sum contract, one fixed amount covers the cost to the owners for the whole project from commencement to completion. This includes labor hours, equipment hours, and all fees and services. The owner controls costs by stipulating in the contract that there will be no payment beyond the scope of work unless specifically agreed to in a formally executed written change order. The contract also stipulates that the contractor is obligated to satisfactorily complete the project regardless of whether the endeavor results in a profit or a financial loss. If unforeseen expenses arise, the contractor is typically responsible for their payment. A contractor will typically not be able to be compensated by the owner for these additional expenses. Conversely, if the contractor encounters a situation in a project that can be completed for a cost that is lower than the bid amount, the contractor can keep the amount saved as added profit. An owner cannot pay less than the agreed upon lump sum. When the project scope can be clearly and accurately defined, most owners prefer this type of contract, as it will limit the total amount that they will pay to the contractor. It can also be advantageous to contractors who are able to accurately estimate the project costs. However, few contracts are so arbitrary that they place the entire financial risk on the contractor. Most contracts contain provisions that provide for costs for certain unforeseen conditions to either be paid by the owner or shared between them based on a predetermined formula. However, the contractor must be aware that an inaccurate estimate is typically not considered an unforeseen condition, and the contractor would bear full responsibility for any financial burden from that error. Unit price contract. In a unit price contract, a project is divided into specific tasks called work units, and a price is attributed to each. The unit price includes labor, salary, fringe benefits, and overhead, and materials necessary to properly complete the task. Profit is also included in the unit price. An advantage for the owner is that the unit price contract does not require payment for uncompleted tasks or contractor inefficiencies. Because the total number of units is usually not known, the total sum to be paid to the contractor is not finalized until the project has been completed. Luna. Okay. Because the total number of units is not usually known, the total sum to be paid to the contractor is not finalized until the project has been completed. The unit price contract guarantees prices for each unit, but leaves the final total project cost relatively open. The unit price contract is a type of fixed price contract. Payment is based on estimated completion of certain well-defined segments of work, with the cost per unit amount determined for each of these work items. The unit costs are those bid by the contractor for performing the work in accordance with the contract documents. Payment to the contractor is made on the basis of work actually completed and measured in the field. Unit price contracts offer the advantages of open competition on projects when the quantities of work cannot be predicted accurately at the time of bidding or negotiation. The unit price contract focuses on the contractor's obligation to complete the project, even though the finished project may have resulted in fewer or more units than originally estimated. The owner is contractually obligated to pay for all the units, even though the number of units may have differed from the projected number. As with the detailed survey contract, provisions can be included with unit price contracts that provide for unforeseen additional unit costs. Regardless of the type of contract, the contract can include a provision for the contractor to receive a bonus if the project is completed early or if the cost to the owner is less than the predetermined amount. Progress payments and retainage. It is essential that the procedures for payment to the contractor be defined in the contract. This inclusion should specify in detail the manner in which the payments will be made, what criteria the contractor must achieve for payments to be made, and the schedule for disbursement of funds. It is also important that the parties who are involved in a project are in agreement about how payment will be made to all others involved in working on the project. Progress payments. A progress payment is a sum paid to the contractor when a specified portion of the job has been completed. This method enables the contractor to receive income while the project is in process. The construction contract must describe the conditions the contractor must meet before the payment is made. Typically, the contractor will file a request for a progress payment before the date the payment is due. With each request, the contractor normally includes a waiver of lien and proof that payments to suppliers and subcontractors are current. The owner or the managing architect or engineer, if the owner is employing one, will certify that the certain segment of the work has been completed satisfactorily and then authorize payment. Retainage. Retainage is a percentage of the progress payment that is withheld by the owner to ensure that all segments of the project are completed as contracted. The contract will stipulate a specified amount that the owner may retain. The contract should state further that the amount withheld as retainage will be paid to the contractor upon verification by the owner that the project has been completed in accordance with the plans and specifications. Additionally, the retainage may be held by the owner until the lien period will have expired with no liens being filed on the project. See Chapter 13, Lien Laws, for information about liens. The contractor should also ensure that contracts with subcontractors cover retainage. The contractor must have the capability to withhold this money from the subcontractors on the project. These contracts should also stipulate when the subcontractors will be entitled to payment. Final payment. The final payment is the sum of money paid to the contractor after the project has been completed and the lien documentation has been completed, and the lien period has expired. This implies that all inspections have taken place, approvals have been granted, documentation has been completed, all the work on the project has been accomplished, and all contractual requirements have been fulfilled. This payment, therefore, includes the final progress payment and the entire retainage amount withheld by the owner. Responsibilities and rights of the parties. Both the owner's and the contractor's responsibilities and rights are stipulated in the standard construction contract. Once established in the contract, these become legally binding and form the basis for future dispute resolution if the necessity should arise. Owner's responsibilities. The owner's responsibilities may include ensuring that the site for the project has met all code and zoning requirements, providing access to the job site, property easements, providing appropriate plans and specifications, if applicable, monitoring the progress of the work without interfering with the independent contractor's methods or management of the project, making timely decisions with regard to changes or substitutions suggested by the contractor, and paying the contractor in a timely fashion as per the contract's requirements. Owner's rights. Owner's rights include selecting an architect or engineer, requiring that the contractors be bonded, reviewing the contractor's choice of subcontractors, inspecting the work as it progresses, using change orders to modify the original plans, materials, and specifications, withholding payments to the contractor for unfinished work, requiring the contractor to provide a warranty guaranteeing that the construction has been completed in compliance with the plans and specifications. If work is found to be substandard or deficient, the warranty will ensure that the defective work is repaired or replaced by the contractor or subcontractor, and seeking recourse if there is a breach of contract by the contractor. The contractor's basic responsibilities include inspecting the site and becoming well informed of site conditions, informing the owner about construction procedures that will be followed, ensuring that the project receives appropriate attention. A contractor may meet this responsibility by employing a project superintendent who is the contractor's agent on site and retains full authority to represent the contractor. Building the project according to the plans, drawings, and specifications. Reviewing shop drawings or material samples if applicable. Maintaining all required insurance or bonds. Verifying that subcontractors have the appropriate license, insurance, and bonds. Supervising the work performed by the subcontractors to ensure that it meets the standards of the contract. Ensuring that suppliers, subcontractors, and laborers are paid. Notifying the owner of any necessary changes, problems, or anticipated delays. Obeying all laws and regulations related to the site and to personnel. Assuring that all required permits and licenses have been obtained and all fees paid. Ensuring that inspections are scheduled in a timely manner. Supervising the cleanliness of the site and overseeing that the site is environmentally and physically safe, and completing the project as specified in the contract. Contractor's rights. The contractor's basic contractual rights include hiring subcontractors, performing the job without interference from the owner, receiving payment as specified in the contract, and seeking recourse if there is a breach of contract by the owner. Change orders and requests for information, RFI. A common practice in construction is that changes will be requested by the owner or suggested by the contractor after the contract is signed. The owner might decide to add or eliminate part of the original project. A design flaw might be discovered after construction has begun that must be rectified. The contractor might request a time extension or the owner an earlier completion date. The contractor might either realize that a different or better method can be employed to accomplish a task, or suggest a change of materials from those that were originally proposed. The standard construction contract will usually have a change clause that outlines change procedures. Some contracts also require that the contractor who encounters a need for modifications after construction has begun submit a written notice to the owner requesting that these changes be made. This notice is also known as a request for information. Although the owner may initiate a change order orally, a written change order should always be executed. The written change order becomes a supplement to the original contract to ensure its validity. The change order should possess both the contractor's signature and the signature of the owner or owner's direct representatives and the date it was signed. Most construction contracts specify that a written change order be issued before work on the change is begun. The change order normally contains a description of the work to be performed, the effect on the completion date, and the additional or decreased compensation required. As it is the case with the original contract, it is of paramount importance that both parties have thoroughly read and understood the provisions of change orders and are aware of their consequences. The law presumes that the parties to the contract are aware of all the facts and documents they have signed. Claiming at a later date that they did not know or understand certain terms or provisions is not recognized as a legal option. If there is any doubt concerning a contract's provision, then the document should not be signed until the item has been clarified between the parties or with the assistance of a lawyer. It is advisable to provide the owner with a summary of all change orders executed to date every time a new change is prepared. This helps the owner realize the complete financial impact of the change orders. A minor change that would not result in significant extra cost or time may not require a formal change order. This type of informal change by the owner is known as a field order. Allowances and substitutions. Often, as part of a contract negotiation, the contractor will offer an allowance to the owner for items the owner chooses to personally select. These items might include tile, carpeting, lighting fixtures, appliances, or even the brick. The allowance is the figure the contractor will use in the estimate for that portion of the work. If the owner exceeds the allowance, a change order will be enacted to cover for additional amount. If the owner's selections are less than the allowance, a change order for a credit will become necessary. Contract provisions may specify exact material or equipment, but permit the contractor to make the substitutions of equal quality. Before the substitution is made, the contractor may be required to obtain owner approval. Subcontracts. On most construction projects, in addition to a contract between the owner and the contractor, there are also contracts enacted between the contractor and the subcontractors. In this situation, however, it is the contractor who promises payment to the subcontractor for providing a specific service or quantity of work. The process for enacting a subcontract follows the same essential elements as that of a primary contract process. The written acceptance must include the acceptance date, specific reference to the offer, unconditional, clearly expressed acceptance of that offer, and both the contractor's and the subcontractor's signatures. The subcontract creates no contractual relationship between the subcontractor and the owner, although the general construction contract may stipulate that the owner or architect must approve all subcontractors. The general contractor may want to insert a contract clause that restricts a subcontractor from further subcontracting any of the work. This will enable a general contractor to remain in privity with the subcontractor, thereby maintaining better control of the work. By means of a flow-down clause, subcontractors are bound by the same obligations as are required of the contractor, but the subcontractor's commitments relate only to the areas that are their direct responsibility. In addition, subcontractors would be bound by the requirements of any incorporated reference documents in the primary contract between the contractor and the owner. These documents might include governmental regulations, separate plans and drawings, and insurance requirements. For these reasons, it is essential that subcontractors read and understand the primary contract between the general contractor and the owner, and all incorporated documents, before entering into a contract with the general contractor. Although oral contracts are generally legal and valid, they may be difficult to enforce. A comprehensive written subcontract covering most of the same information found in a general construction contract will enable the contractor and the subcontractor to work toward the same goals and to avoid potential damaging disputes. Virtually all subcontracts made that the general contractor must pay subcontractors promptly following payment by the owner. Some states have prompt pay requirements covering when contractors are to be paid. Some contract will also contain clauses relating to the progress payments, retainage, and bonding. Payment methods are outlined in the contract, with compensation to the subcontractor based on a lump sum, unit price, or cost-plus arrangement. The general contractor / subcontractor contract would most likely address what would occur in the event that an owner did not pay the general contractor. Let's get it. If any party fails to abide by the stipulations of a contract, this is known as a breach of contract. A breach of contract may be a major violation, which would be a material breach, or a less important infraction known as an immaterial breach. The Standard construction contract explains how contractors and owners may seek a resolution for breach of contract, how to terminate the contract, and how to appeal the decision. The contract will also specify who will pay the costs of arbitration, legal counsel, and court costs. Several factors are taken into account when determining whether a material or immaterial breach has occurred. These include the magnitude of the obligation that had not been completed, whether the breach resulted from negligence, whether the breach happened with the conscious knowledge that harm to the non-breaching party would occur, the amount of harm that would ensue, the degree of remedy that would be required, and whether or not the non-breaching party could have acted to lessen the harm. It is not always easy to determine whether a breach will be considered material or immaterial by a court of law. Since either party may sue for damages, the contractor should be very wary of refusing to perform work designated by contract unless there is a strong and definitive evidence that the other party has prevented the contractor from completing the work or has overtly and materially breached the contract in some manner. Material breach. A material breach is a violation of a contract deemed serious enough to destroy the value of the contract and to provide a basis for an action of breach of contract. If one party to the contract fails to abide by an essential provision of the contract, then a material breach occurs. An example of a material breach by the contractor would be a failure to continue work on a project. A material breach by the owner would be a failure to pay the contractor for work completed in accordance with the contract. To be compensated for a loss resulting from a material breach, the non-breaching party may sue for monetary damages and under some circumstances force the party who has breached the contract to complete the work as stipulated in the contract specific performance. Immaterial breach. An immaterial breach is one in which the violation does not significantly lessen the value of the contract for the other party or result in significant harm. If one party to the contract fails to perform a less significant task, then an immaterial breach has occurred. The non-breaching party can sue for damages if there is sufficient proof that a loss resulted from the breach. Although damages may be awarded, the non-breaching party cannot terminate the contract for immaterial breach. Breach for contract remedies. When a breach for contract occurs, the non-breaching party must decide whether or not to seek a remedy or what avenue to follow in this pursuit. The non-breaching party may elect to take legal action and to sue for damages, or to void the contract. Alternative dispute resolution is another option available to the parties, especially if dispute mechanism methods have been included in the original contract or in later written agreements. Some jurisdictions require alternative dispute resolution be attempted prior to the courts being asked to intervene. Mediation. An alternative to avoiding the long and costly process of litigation is mediation. A mediator with special training and knowledge of construction law will preside over the proceedings. Generally, each side in the dispute agrees to the selection of the mediator, and each pays half the costs. The mediator hears the claims, reviews the facts, and tries to guide the parties to reach an amicable agreement. Although mediation is not binding, if both sides can find an agreeable resolution, the mediator will help prepare a written document detailing the settlement's provisions that will be followed by both parties to the dispute. Binding arbitration. If efforts to settle a dispute through negotiation and mediation fail, the court may appoint an arbitrator to settle the disputes if there are relatively low economic damages claimed. The arbitrator will conduct a hearing similar to a trial and will issue a ruling that is binding on the parties. This ruling can be enforced through courts. The advantage of arbitration over litigation is that the process is usually completed in a much shorter time span and at a much lower cost than for court trial. Litigation. One option is litigation and the use of the court system to remedy the complaint. The desired outcome for the non-breaching party is to have the court award damages as compensation for economic losses arising from the breach of contract. Court trials are more costly than other methods of dispute resolution and generally take longer to reach closure than the following alternative procedures. Surety bond. One way that the owners or developers can protect themselves from future risk that the contractor will not complete the construction is to require that the contractor be bonded. A contract surety bond is a three-party agreement under which a surety company guarantees that the contracted work will be completed by issuing the bond. The surety company assumes financial responsibility for the contractor and will pay the owner's claims against the contractor's company or even assume responsibility for completing the project. The surety bond functions as a credit guarantee to the owner. It does not function to protect the contractor from financial loss. The bonded contractor is responsible for repayment of money spent by the surety bond company to settle a claim or complete a project. A surety company typically requires that the contractor meet certain minimum standards for working capital and other financial ratios before it will issue the surety bond. A more detailed discussion concerning various types of bonds can be found in Chapter 5, Risk Management. Refer to Chapter 10, Licensing Laws, for information concerning the license bond requirements. Thank you for listening to the Construction Business and Law Manual for Nevada, Chapter 8. Please review Chapter 9.